let's go into the first plenary session. As the Dean has mentioned, it's about professional negligence. So often when you plan a conference, it's quite tricky to actually, find common themes between speakers and to put the different speakers into panels. But we didn't have that problem at all, actually, this time around. They fell wonderfully, so we've got I think a great session to look forward to now on establishing professional negligence. Our first speaker is Professor Gary Chan. He's a professor of law at Singapore Management University. Many of you will know, that his research interests, apart from torts law, are also the Singapore legal system and health law and ethics. He published many papers on torts law, including a leading book on torts law in Singapore, and his work is cited regularly in common law courts around the world. Gary, I hand over to you.
Thanks very much, Norman. It's a great privilege to be able to speak in this conference with so many participants, so many distinguished speakers. First, may I share the screen for my slides?
Yes, please, that would be best. Yeah, it's working.
Okay, that's great. Hope all of you can see that. Right, so my topic for today, as mentioned earlier, is on the theme of professional negligence. And my main focus is really on the standard of care for medical advice to patients with mental health conditions. I'll be focusing mainly on the Singapore statutory law concerning the standard of care for medical advice. This is a tort reform in that sense by way of statute in Singapore about 2 years ago in 2020. And for this particular topic, I'd like to focus on not just patients generally, but patients with mental health conditions. By that, I mean patients who may be suffering from clinically diagnosed mental disorders, as well as patients who do not suffer from mental disorders, but their mental capacity may be reduced. And this is clearly relevant with respect to doctors giving advice, because after all, they are the recipients of the advice. Right? So what I plan to do is to work out this topic and the analysis in the following way. First, I'll give a bit of background. It will take quite a few slides actually, because the law has fluctuated, if I may say so. And now it has a landing point in the form of this new legislative framework, now known as Section 37 of the Civil Law Act. But I would argue, and I hope you'll be clear as I go along, that the common law approach, the case authorities, at least some elements of them will still remain relevant when we interpret the new legislative framework. With regards to patients with mental health conditions, I'll look at a few issues. I think the first one is to focus on patients with clinically recognized mental impairments or mental disorders. And for that, we have to see the interaction between the new law, Section 37, and the Mental Capacity Act. This is followed by 3 other issues. Of course, I think patient autonomy will be relevant here, since it's a question of medical advice. And I'll also say a bit about participation, what it really means, and some related issues. The new law in Singapore, the statutory law, also talks about the reasonable patient and what the particular patient wants. And finally, I will touch on whether there are certain exceptional circumstances or situations whereby the doctor may be justified in withholding some disclosure of information from the patient. And I'll focus on one exception called the therapeutic privilege. Okay, just some background. You'll take a few slides, so just a slight disclaimer there. We'll start with Koo James and Gunapati case. Right, so this is a Singapore Court of Appeal case back in 2002, where the Bola and Bolito test was challenged, right? And the High Court in that case said that there's no need to apply Bole and Bolito to the standard of care for judging medical advice, all right? However, the Court of Appeal disagreed with that and said that we should maintain status quo. We should apply Bolem and Bolito tests to medical advice and not just diagnosis and treatment. Bolem, as you know, it's about deep deference to the medical profession, all right? So as long as there is a segment or respectable segment of opinion, medical opinion, that supports the doctor's practice as acceptable, then the doctor is not negligent. And Bolito talks about subjecting such a medical opinion to the test of logic. Right. In 2015, what happened in UK? UK departed from the status quo, and they actually rejected Bole and Bolito for medical advice or to assess medical advice. Right. They adopted a more patient-centric approach, and in the quote there, it talks about the test, this patient-centric test, right? So in lieu of Bole and Bolito, the question here is whether in the circumstances of the particular case, a reasonable person in the patient's position will be likely to attach significance to the risk, or the doctor is or should reasonably be aware that a particular patient will be likely to attach significance to the risk. So for Montgomery, the focus is on risk. And you see there the concept of a reasonable patient, as well as the concept of a particular patient and what they regard as significant in terms of risk. Okay, now the Singapore approach. So you can see 2 years later in Hitchcock, and I'll mention this case a few times, they followed Montgomery with some modifications. So similar to Montgomery, they rejected Bole and Bolito for medical advice. We don't need to consider Bolem anymore. In place of that is a 3-step inquiry. Okay, first, what is relevant and material information? And you can see the test there is quite similar to Montgomery. Okay. There is a slight difference. Over here, we're talking about information in general, rather than just information relating to risk in Montgomery. But you see there concepts of reasonable patient, as well as concept of what the particular patient would regard as important. So that's quite similar. Second step, the court should also consider whether the doctor possesses the information, say through proper diagnosis, for instance, right? And for that, you still apply the Bole and Bolito test, right? So the question is, if the information is relevant material and is in the possession of the doctor, it should be disclosed, right? Based on the first 2 steps. However, there's a third step that says that in some exceptional circumstances, that may not be necessary. The doctor can withhold disclosure. One example is where the patient waived the right. Second, therapeutic privilege, which I'll talk about a bit later. And emergency situations, where it's not possible to obtain the consent of the particular patient. I should also mention that Hitchcock also talks about quality of communication, right? So how the doctor communicates to the patient, for example, don't load with technical jargon, making sure or taking reasonable steps to ensure the patient understands the information. Okay. We come now to the current position, but before that, I just want to mention that the medical profession in Singapore wasn't exactly thrilled by the Hitchcock test, right? They felt uncertain. They're not sure on the ground how they're going to react to the patient, taking into account the court decision. And there was at least anecdotal evidence that it may have led to some defensive practices amongst the profession. Hence, the government took action by appointing a work group to make recommendations. And to some extent, the Section 37, the new law, took some inspiration from the work group recommendations. Okay. You take a look at the requirements there. How did they define standard of care in relation to the provision of medical advice? in section 37. So you can see the first is about pure professional opinion. That reminds you of Golem Test. Over there, they talk about the manner in which the healthcare professional acts and whether it's accepted by a respectable body of medical opinion as reasonable professional practice. Okay. Second, similar to Bolito, whether the pure professional opinion is logical. And within the statute itself, it explains what it means by logical, i.e. whether the opinion has directed its mind to the comparative risks and benefits, and whether it's internally coherent as well as consistent with extrinsic facts. Okay. So basically what section 37 is doing is that it's to some extent reverting to the Bolem-Bolito test as that basic framework. However, right, it's not pure Bolem-Bolito because section 37, subsection 2 says this. The pure professional opinion, if it's to be relied by the court, must consider A and B, right? If you look at A, it may remind you of what was discussed in Montgomery and Hitchcock. A part 1, I think, to some extent, relates to the reasonable patient perspective. What the person in the same circumstances as the patient would reasonably require, objective test, right? Require for what? To make an informed decision, whether to undergo treatment or to follow medical advice. Part 2 talks about what is material for the patient in question, for the purpose of making an informed decision. Right? And finally, you'll see that in 37(2)(b), in order for the opinion to be relied on by the court, it must also consider whether the doctor had any reasonable justification for not providing certain information, Okay, so this is the structure. Okay. How will all this apply to patients with mental health conditions? So let me start by looking at those patients with clinically diagnosed mental impairments. And how does it relate to how does it affect this question of patient autonomy, which Montgomery, Hitchcock was trying to promote, and which section 37 now encapsulates in some form within the provision. Okay, how does 37 interact with the Mental Capacity Act? 37(2)(a), the slide that I've just showed, seems to presume, right, that the patient in question is capable of making informed decision because they're providing information so they can make an informed decision, right? And if it's capable of making informed decision, there's that duty to disclose the relevant information. What does mentally capable or incapable mean with regards to the patient? And it's defined the MCA. The presumption is that everyone is mentally capable of making a decision. So if you want to assert that he is not, you have to prove it. 3 things you have to prove: clinical incapacity, to be decided by doctors. Second, functional incapacity, to be determined by the court. And third, that the clinical incapacity has impacted on the functional incapacity. All right. Just a note on functional incapacity, you take a look at it in terms of background, it refers to 4 criteria: understanding information, retaining, that means remembering the information, ability to use or weigh the information, and the ability to communicate the information, the decision, sorry. So as long as one of these is missing for that particular patient, then he would have satisfied functional incapacity. He's functionally capable of making the decision. And assuming A and C are also satisfied, then he is mentally incapable of making the decision. Okay, does 37 refer to this? Not specifically. Doesn't refer to Mental Capacity Act, but it does say that if a patient is under legal disability, and I think that there's some connection there to mental competence to make a decision, right? If it's under legal disability, then 37 says, then you look to the person with the responsibility to make a decision, i.e. the legal proxy. That means that the doctor would still have to disclose the relevant information under 37, but in this case to the legal proxies. Since it's the legal proxies are the ones, who have the responsibility to make the decision on behalf of the patient. So I think that's one interaction. Still on Mental Capacity Act. Okay. One thing to note is that patients with clinically recognized mental disorders, right? Yes, they may be functionally incapable of making a decision, but not always. So it really depends. So the court really has to assess. So a person, say for example, in this case, a bipolar disorder, yes, he has a clinical incapacity, but he may still be able to make a decision regarding a health-related decision. All right, so it can actually go both ways. There's some literature here concerning functioning capacity. Some argue that it tends to be about cognitive abilities, about rationality, because of the use of the words like weighing the information. Just show that there's some rationality, deliberation involved. But looking at some of the English cases on MCA, it seems that the courts are quite willing to take account of the mental challenges that patients may have, and they do try to fit it within the functional incapacity test. Okay, some of these patients with mental health challenges, right, may lack an insight as to their illness. That means they're not totally certain of what their illness entails, really, right? And in such cases, the courts have said that, oh, that could actually relate to the inability to understand information. In this case, information about their illness, because they do not know the real consequences, right, of the prognosis of the illness, for instance, right? So they fit it within MCA. And then as a result, the patient may be considered as mentally incapable. We have a Singapore Code of Practice in MCA with examples concerning schizophrenia. If you have delusional beliefs, right, the illustration says that it's possible you can't use or weigh information. If you think that your family members, instead of helping you with the treatment, or the hospital, instead of helping you with the treatment, are trying to harm you. But there's a qualification here, i.e. that the fact that you are mentally incapable, you cannot be considered as mentally incapable just because the decision was unwise, right? So you cannot reason just based on the actual decision that was made. Now we move out of MCA framework. So we consider patients who have autonomy, right, but reduced capacity. They do not suffer from a clinically recognized mental disorder. How do we deal with Section 37? So I'd like to argue that patient autonomy is important, but we should consider the other side of the coin, the doctor's professional autonomy. Right? He is guided by ethical codes and guidelines, for instance, or some medical practices. Right? How does it impact on medical advice? If you look at 37(2)(a), it seems to be focusing on what sort of information to disclose to the patient, right? Based on reasonable patient test or the particular patient test. What it doesn't do is consider whether we should apply the shared decision model. Okay. The thing about shared decision model is that there seem to be quite a number of interpretations of it, but I'm now taking the interpretation that it means patient and doctor makes a joint decision as to the treatment. One problem with this is that 37(2)(a) assumes that it's the patient who makes a decision rather than a joint decision. 37 also doesn't talk about a doctor's role in helping the patients interpret his values and preferences. It doesn't talk about the quality of patients to ensure that the doctor takes little steps to ensure the patient understands the information. It doesn't talk about participation of the patient. But Hitchcock and the Singapore Medical Council ethical code and ethical guidelines do relate to that. Okay, looking at the time, I think I have 5 minutes left. Let me proceed.
I think only,
few more slides.
only 1 or 2 minutes actually. So.
Oh, okay, sorry about that. Okay.
Thanks for asking.
Just a quick one on this particular slide. Right. So peer professionals, of course, have to assess the reasonableness of the information required by the patient. So you can import some of the factors from Hitchcock itself on the objective factors. What are the risk factors? How severe the illness is. This is what a reasonable patient would probably want to know, right? And you also have to consider what the particular patient wants to know based on his specific questions or queries or concerns he may have, maybe concerning his mental illness, right? And of course, doctors will assess whether, the court has to assess whether the opinion is logical. Just on the last one, and then I'll conclude. This last point is about therapeutic privilege. Okay. The funny thing about this statute is that it talks about the waiver exception, it talks about the emergency exception that was in Hitchcock, but it was silent on therapeutic privilege. Leaves us to wonder why. Is there a particular reason why they don't talk about therapeutic privilege? I would like to argue that notwithstanding the silence on the exception of therapeutic privilege, we can still import therapeutic privilege from Hitchcock and other common law cases, as long as they are not inconsistent with the statute. And in Hitchcock, these are some of the principles there. First, it's a case where a patient has reduced capacity. Therapeutic privilege is an exception, patient autonomy, and they've used beneficence as an argument to support therapeutic privilege. And the 3 conditions for therapeutic privilege mentioned in Hitchcock are as follows. Does it benefit the patient? Does the treatment benefit patient? Second, is there a low risk involved in the treatment? Third, is there a likelihood that if the doctor were to disclose the information, the patient would reject the treatment that was beneficial due to some misapprehension? If so, then doctor should be justified in withholding information. But I also want to highlight this, which is that they also talk about another approach, which is based on what I'll call non-maleficence, right? So there may not be actual benefit, but the doctor assesses that the patient is likely to be harmed if he were to disclose the information. Okay? And Rogers, for example, the Australian case, refers to that. Is there a risk that disclosure would harm an unusually nervous, disturbed, or volatile patient, which is very relevant for a patient with mental conditions? Okay. Finally, how do we use Hitchcock to interpret, or use common law to help interpret this new statutory law? I argue that the criteria of quality of communication with the patient and ensuring that the patient understands, I think, should still be important. And it's hoped that the peer professional opinion would incorporate this where relevant. Another relevant criterion or component to include in the peer professional opinion would be whether the doctor's actions have encouraged or enhanced the participation of patients, because this is under Hitchcock and the SMC ethical code. And thirdly, that for therapeutic privilege, the court should be in a position to assess whether the professional opinion is logical in the way they assess the application of therapeutic privilege by looking at the comparative risks and benefits of withholding information or otherwise. Right? With that, I conclude. Thanks very much for your
Thank you very much,
yeah.
Harry. Yes, so there's probably plenty of questions that people might have. There's complex new laws, and more nuances that you can see from the developments in Singapore. If the audience members have any questions, so our standard practice is that you put them in a chat message to me, and that I'll ask them at the end, when we have a Q&A session. So all the topics in this session are quite closely related. So I think the best approach is just to have a single session at the end. And please don't hesitate to ask any questions or make any comments that you'd like to our speakers to respond to. Okay, so our next presenter is Professor Chaitra V. Professor Chaitra is an assistant professor at Christ University, Bengaluru, Karnataka in India. Her research interests are tort law, law of insurance, and the interpretation of statutes. And her topic for us is examining the standard of care in medical negligence with a special reference to India. So, Professor V, the floor is yours.
Yes. Am I audible, Professor Norman?
Yes, we can hear you well.
Thank you. Thank you so much. I'm trying to share my screen. Professor Norman, hope I'm audible loud and clear, and hope my screen is visible too. Yes, thank you so much. As Sir mentioned, I'm Chaitra V, Assistant Professor at School of Law, Bangalore, India. Yes, the topic of my presentation is examining standard of care in medical negligence law with special reference to India. Moving on to the motivation and the problem statement. It's clearly established that doctors owe a duty of care towards their patients, and any breach of this duty results in medical negligence, tort of medical negligence. The long-established test in India has been the Golem Test, which we have borrowed from the English schools, which means in India, a doctor is not liable for medical negligence if he has followed a practice which is acceptable to medical science to date, and if it is testified as appropriate by body of medical experts. So which means if a doctor follows the procedure amongst other procedures by treating or diagnosis, and if that results in a failure, he cannot be held liable for medical negligence if it is testified by body of medical experts as appropriate. Now, the Golem Test application in India has certain ambiguities. In practice, although the expert testimony can be produced by both the parties, that is the victim of the medical negligence and also the doctors of the hospitals, or sometimes it can be court-appointed expert body, there is no clarity or guidelines with respect to the number of doctors required to form the body of expert opinion. And also it has been seen by some of the commentators that Golem Test has been disproportionately biased towards the doctors. I mean, I just want to quote various reports here. It has been reported in India that even though the number of medical negligence cases that has been reported has been increased, the ratio of successful claims has been lesser, for the simple reason because the doctors are always hesitant to testify against their own peers. So that is one of the approach that we were looking for as far as the Golem Test criticism was concerned. So in this test, in this paper, I have tried to examine the approach adopted in India to determine the legal standard of care in deciding the tort of medical negligence. So just proceeding further to my presentation outline. This is my presentation outline. Firstly, I'm just briefly discussing Golem to Bolithos, like how the English courts have shifted from Golem to Bolitho. Did it really impact the Indian courts is the first question. Then I'll just take through the analysis of selected case, how there has been ambiguity in the application of the Golem Test, some few best practices from the selected jurisdictions, followed by conclusion and suggestions. Quickly going through the Golem Test, it's very well established here. If a practice or adopted by a doctor is acceptable to medical science or aid, and if it is testified as appropriate by the experts, then the doctor cannot be held for medical negligence. But just briefly stating the facts here, the doctors and the hospitals were held liable for using the electroconvulsive therapy without using any relaxants before giving the treatment, or without using any manual control, or without giving any warning to the patient, and he consequently suffered from physical injuries. But later on, the doctors were able to provide expert evidence before the court of law that it was not the usual practice to use relaxants because there was associated mortality risk, or it was not the usual practice to use manual controls because it escalated the risk of fracture. So basically, Golem's test indicated that deciding liability in medical negligence was a matter of medical judgment with minimum intervention of the court. But we see in the year 1997, the English courts urged the lower courts not to rely upon the Golem test and to see that the court scrutinizes the expert opinion based on reasonableness. So what I understand here is the current position that they have moved away from the Golem test, enabling the courts to scrutinize the medical expert opinion upon its reasonableness. Now, moving on to the Indian position, as far as the application is concerned, we still use the Golem test. It was approved in Jacob Matthew case in the year 2005 by the Supreme Court of India. It was a 3-judge bench. They approved the application of Golem test, which continues to precedent even today, which means there has to be expert opinion, and if there is a body of doctors testify that this procedure that is followed by a doctor is appropriate, then he cannot be held liable for medical negligence. Of course, in the year 2010, Kishan Rao's case made an observation that even the English courts have moved away from the Golem test and they apply Bolito test, which means the courts can rely upon the medical expert opinion, but they are supposed to scrutinize upon its reasonableness. But despite this, they couldn't overrule Jacob's case for the simple reason Jacob's case was decided by a larger bench. I would want to go through some of the cases just to convey my the issue that I've highlighted here. In Dr. Shivaji Basu versus Deviya Ghosh case, very interesting case here. The patient was suffering from kidney ailment and he was prescribed a medicine wherein he suffered from hearing impairment because of the overdosage. When he sued the hospital and the doctors, they provided expert opinion which showed that the medicine that was prescribed was within the prescribed limit for an adult. But here the patient was not able to provide any medical expert opinion. On the other hand, the doctors who provided the medical expert opinion could not provide any clarity as to whether the medicine was within the prescribed limit for a patient suffering from kidney ailments. But also in this case, very interestingly, there was a lot of medical literature found which clearly said that this medicine had to be prescribed, monitored carefully by the doctor, otherwise it would be affecting human audiology. Now, interestingly and unfortunately here, the patient was not having any expert opinion and the doctors provided 2 expert medical witnesses wherein they said that the medicine was within the prescribed limit. Although the medical literature said otherwise, the court decided in favor of the doctor because they were able to provide 2 competent medical witnesses, expert evidence here, despite having the medical literature. So that's why, in this case, there has been a lot of reliance upon the Golem test, upon the medical testimony, and the medical testimony prevailed over the medical literature. And there are various other instances. Due to paucity of time, I have not put it into my slide. There is one more case law wherein in Samera Kohli versus Dr. Prabha Manchanda's case, the treatment that was, she approached the hospital was for endometriosis, and it resulted in the removal of her uterus. The question here was whether removal of uterus was the appropriate treatment when the endometriosis was spread. There was conflicting opinions. There were body of doctors who were testifying that it is the appropriate treatment. On the other hand, there were body of doctors which said that that was not the appropriate treatment. But here the patient again failed to give medical expert testimony, and it was held that the doctor had acted as per the recognized practice. There are various other instances wherein there has been always conflicting opinion about the practice that is prevalent and also the medical literature that is available. Through the study of the cases, it has been observed that in India, in the medical negligence proceedings, the medical expert opinion prevails over the medical literature. Now, the fact of the matter here is that when the doctors come and testify before the court of law about the clinical experiences and support their colleagues, it is very difficult for the court to actually test the validity of those clinical experiences. So in these cases, probably the admissibility of the relevant medical literature should be accepted to further substantiate the point of the doctors who are come and testifying it before the court of law. Now, just to proceed further to take some of the good practices or contemporary practices in the other jurisdictions, all these countries like Australia, USA, Canada rely upon medical expert testimony, but at the same time, the court really scrutinizes upon its reasonableness. For example, in Australia, there have been a distinction. Now, if there is a standard of care required with respect to diagnosis and medical treatment, yes, the doctor's opinion will have a conclusive role. On the other hand, if the duty of care or reasonable care is with respect to the relevant information to be given to the patients about warning of the risk, in those cases, the court takes the decision because the High Court feels that there is no special skill needed in these matters when it is about warning the patient about the risks involved. I would also now talk about the US Supreme Court here. They also rely upon medical expert testimony, but they stress upon the scientific validity of expert witnesses. Whenever they consider expert witnesses, these following things are taken into consideration. That is whether the reasoning or methodology underlying the medical testimony has been empirically tested, or whether such reasoning or methodology has been subjected to peer review and publication, whether there is known or potential rate of error and general acceptance by the scientific community. Moving to the Canadian position, I mean, this is a very interesting case, which I would want to cite the facts. In Anderson's case, there was the issue about removal of tonsils, and in this surgery, some sponges were left in the nasopharynx of the patient. Now, when the doctors and the hospitals were sued, the doctors were able to get medical testimony to the fact that it was a usual practice that the sponges were not used without any strings, and it was possible of such obvious risk to arise. On the other hand, there were also the doctors who used these sponges with strings. But now, although the doctors here provided expert testimony to the fact that even the sponges could not be used without the strings, the court here decided against the doctors. I mean, they clearly said that if there are two methods available, the method which is likely to reduce the obvious risk has to be adopted. So basically here, just because there is a group of doctors testifying that this practice has been followed and it's a usual practice, the court totally discarded that argument of the doctors and expert testimony. So basically, in other countries, I just want to sum up here, apart from relying upon the medical expert testimony, it has also been observed that the court do look into the reasonableness of the expert testimony. Now, just moving on to the conclusion and suggestions, these are some of my observations. Now, India needs to revisit the Golem Test, not strictly adhering to the Validity test. The court must not entirely rely upon the expert medical opinion without going into its reasonableness. And also very important here is just merely relying upon medical expert testimony. As I clearly mentioned, it becomes very difficult for the courts or the judges to really test the validity of the clinical experiences of the doctors who come and testify before the court of law. So it should always be accepted only with the supporting medical literature, peer-reviewed, empirical tested. So taking a cue from the US decision, the competent authority in India, Medical Council of India, can come up with certain guidelines wherein the medical literature also could be acceptable along with the medical testimony of the doctors. Now, as I clearly mentioned, doctors may be a little hesitant to testify against their own peers. Sometimes it puts a lot of burden, stress on the victim of medical negligence to really produce medical expert opinion before the court of law. So in that case, mandatorily appointing expert panel by the courts is desirable. So with this, I conclude my paper presentation. Thank you so much.
Thank you so much, Chaitra. That was a wonderful ride through, the Indian law, and also well within time. So thank you very much. I hope we've got enough opportunity for questions later on. So I'll, zip my mouth for now and move on to our next speaker. And our next speaker is Mr. Nicholas Liu, again from Singapore Management University. Nicholas is a lecturer there. He previously clerked at the Supreme Court of Singapore and also practiced in dispute resolution at a leading Singaporean law firm. His topic for us today is codifying professional standards in negligence, problems and promises. So you will see, or can see already the connections between the various topics. So yes, Nicholas, over to you.
Thank you very much, Norman. I'm just going to try to share my screen. Hopefully that will work. Is that working all right?
Perfect.
Okay, wonderful. So thank you so much for the opportunity to be here. I note Professor Whitslop's earlier comment that this plenary session ended up being quite harmonious in its theme. As a result, I actually have a lot less to say than I thought I would, because among other things, my colleague Professor Chan has covered a lot of stuff about the codification in Singapore of the professional standard of care in medical negligence, which I'm focused on. So I'll try to just keep it quick and stick to things that are new. My focus here is not so much on the doctrine and more on the distinction or lack of distinction, I argue, between rules that really have to do with the substance of tort law, specifically the content of the standard of care, and rules that are actually more evidential in nature. Related to the second, there's also an even sometimes more confusing question of when you have things that aren't even necessarily rules at all, but are just examples of facts that could satisfy a particular rule. My argument is that really this is an area where there's a lot of potential for added clarity through codification, but at least in Singapore's case, the recent opportunity to get that added clarity hasn't really been seized. So just for a bit of context, but most of it has actually already been provided by Professor Chan. We went from accepting Golem Bolito to a slightly modified position, actually, well, a hugely modified position with regard to medical advice, adopting Montgomery and Hitchcock, and then the Civil Law Amendment Bill was passed to basically revert the position with some modifications. I'm going to start by giving an overview, not of the whole development of that, but just a little bit of contextualizing of what the substantive rules of negligence are and how they relate to more specific tests. I'll then move on to some ambiguities with regard to which parts of these are substantive and which are evidential, before discussing how Section 37 doesn't quite provide the clarity I've been hoping for, before concluding with how we might find a way forward that is a little bit better, given the limitations. So as everyone here, of course, knows, in general, negligence is really just failing to do what a reasonable person would do. And here there's no difficulty seeing that this is definitely a substantive rule. It's not that the reasonable person is just an evidential tool to figuring out what the standard is. The reasonable person is the standard. The professional standard of care is pretty much the same with a little bit of added context. We look at the ordinary skilled person exercising and professing to have that special skill. And again, it's pretty clear from the language in Golem and in other cases that we are here talking about what people actually are required to do. It's part of the norm of carefulness that is at the heart of negligence. It starts to get a little less clear when we look at the specific test in Golem and the addendum in Bolito. The statement here is that a medical person would not be negligent if, quote, acting in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. And this, I think, is where a lot of the confusion began. And here I'm not really even talking about the confusion between a practice in terms of something that doctors were actually doing at the time, which is something that I think Dr. Harder will be talking about later. But the even more basic question of whether, when you talk about a practice or in some other cases an opinion, we're talking about the opinion of the person testifying before the court as to what they would do, or a sort of opinion or practice that is out there in the world. The Bolito addendum, I think, makes things even murkier, because we're talking here about when the court can reject the opinion proffered by a peer within the field. And here it's a little bit, I'm not going to cover the substance here, but it's a little bit unclear whether what is happening is rejecting evidence offered by the expert or rejecting the opinion that the expert's evidence has established as existing out in the medical community. A lot of this was, I think, clarified somewhat by the court in Hitchcock. The court described the Golem test as a practical mode of implementing the more general standard, which to me suggests that it must be substantive as well. When we talk about a body of opinion that someone acted in conformity with, we're talking about something that is sort of out there and not just the opinion that is being provided to the court, because otherwise it wouldn't make sense to speak of it as a proxy or heuristic for the general standard. It would instead be an evidential tool for determining if the standard has been met. So let's get past this stuff, because I think all of this has been well covered already, although it's a waste of the animations that I made. I'm going to move right on to the ambiguities and why they matter in a little bit more detail. So I've already kind of started going into it, but I'm going to get a bit more specific about what those ambiguities are. The first I've already alluded to, which is whether we're talking about the opinion of the expert or an opinion evidenced by the opinion evidence of the expert. The second question stemming from that is that if they are different, what is the court rejecting? The opinion out there or the evidence in here? And thirdly, and this is a sort of broader question arising out of the previous two, when we talk about the Golem test setting out a standard of conduct, are we really committing a kind of category error? Does it set out a standard of conduct, or does it set out evidential mechanisms for establishing facts that will tell you whether the relevant standard has been met? And this is where I think a close reading of the judgment Hitchcock actually provides a great deal of clarity, because in the midst of all this discussion of autonomy and medical paternalism and all this stuff that the case became famous for, there's actually a really interesting snippet here, well, not a snippet, it goes on for some pages, on what exactly the Bolito addendum is and when it operates. The court made the point that the Bolito addendum and indeed Golem are really only triggered once certain evidential decisions have been made. The scope of the Bolito addendum, as this paragraph of the Hitchcock judgment says, extends only to the court's approach to a body of opinion that has been shown to exist. And beyond, outside of this, or logically prior to this, there's the question of whether, based on the expert's testimony, the court is convinced that there really is such a body of opinion out there and that it has been properly reflected in the expert witness's testimony. And the court says, what is assessed under the Bolito addendum is the logicality of a body of opinion of which the existence and content have already been proven. So here we see the Court of Appeal in Heath drawing an unusually clear distinction between those aspects of dealing with expert testimony that are evidential and those aspects that are substantive, having already found that the body of opinion is out there. So if we were to go with he, I think there would be quite a bit of clarity. And this is something that I had hoped might make its way into the form of Section 37 of the Civil Law Act as amended, which Professor Chan has already gone through in the wording. That didn't really end up happening. Instead, the focus, and of course this is perfectly understandable, was on the hot button issues in he, right? The question of what sort of test we use for medical advice and sorting out all those substantive matters. So it's perfectly understandable that the focus was there, but there are just some things about the way it's phrased that I think are a little bit unfortunate and even a bit of a setback. So one thing that's notable here is that the reference is to a respectable body of medical opinion. We can see that in 37 sub 1 sub A, and then that's abbreviated to the peer professional opinion. And that it reintroduces, or at least preserves, the ambiguity I noted earlier, where you're not really sure when you look at a phrase like this, whether you're talking about the opinion that the person in the witness box is giving to the court, or the opinion that they are trying to establish exists somewhere out there. This is, I think, made a little bit worse by the fact that in subsection 2 of section 37, the reference here is to reliance. It says, in order for the peer professional opinion to be relied on for the purposes of that subsection, the peer professional opinion must satisfy these requirements. And then those requirements are phrased in terms of what kind of information has to be given and all that. And once you start talking about requirements for placing reliance on opinion, then that starts to sound really evidential, because we're used to thinking in such terms when we talk about relying on expert testimony in general. So there is, I suggest, at least an ambiguity here. It's not clearly phrased in evidential terms, but it has a kind of evidential flavor to it that might start to muddy the waters. The last interesting and also, in my view, troubling feature of just the way this section is drafted is how the draftsman dealt with the illustrations to do with the therapeutic exceptions to disclosure. And then that is something that Professor Chan also covered earlier in terms of the substance. So I'm not going to retread any of that, but what I want to flag is just that these illustrations all correspond to what were previously thought of as substantive defenses to non-disclosure. They were specific reasons the doctor could cite for not disclosing something, even though, of course, in each court, the court also said that the categories aren't closed. It's kind of strange, I think, and not really good for clarity to I wouldn't say, I was going to say smuggle, maybe that's not quite right, but to shoehorn them into a list of illustrations to this previous subparagraph, sub 2b, illustrations basically of what constitutes reasonable justification for non-disclosure. And this, I suggest, gives rise to an even more potentially troubling ambiguity, which is whether these illustrations map to reasons the court can directly use to reject opinion, or whether these are things that the expert opinion is supposed to consider in giving the decision. And what I mean by this is that if we were to view these illustrations as somehow still capturing the substantive defenses, then logically what a court would do applying this section would be to say, okay, the expert, the peer opinion said that it was okay not to disclose this information, but when I look at the illustrations, it doesn't map, and so I just reject it. So that would be a more direct exercise of curial oversight. But you could also look at these illustrations as guiding the expert's opinion or the expert's reasoning process when they determine whether there was reasonable justification for non-provision of information. And then what happens to the court's oversight? Is that something that itself has to be Golem bully-throwable? So the court would then have to say, well, all right, in finding that even though it doesn't fit within any of these illustrations, it was reasonable to withhold. I just need to ask whether there was some logical basis for it or what. So I think this introduces an additional level of uncertainty as to who is supposed to be making the call as to the applicability of these defenses. An uncertainty that I suggest would not exist if the statute had preserved, or I shouldn't say preserved, but had provided for more clarity on what is substantive and what is evidential. So, long story short, I don't think it has clarity. I think it makes things a bit worse. I think there was promise in Hitchcock formally that could have been made better use of. But on the bright side, and this brings me to the last part of my presentation, I think it is possible to improve the situation a bit through a principled and careful use of judicial amelioration of the statute. Because as I said, there's nothing in Section 37 that requires one to view some of these things as evidential points rather than substantive ones. There's also nothing in Section 37 that actually overrules He, which is notable because there have been other statutes that have explicitly said, for instance, oh, this tort that was recognized in this case is abolished, or even other examples, specifically rolling back case law to a particular date, although that's not in the context of private law. So here, basically, everything that's not inconsistent with Section 37 that was in He still remains. So all that stuff about the distinctions between evidential treatment of expert testimony and the analysis of the opinion once established under Golem Bolito is all still there. And logically, that should inform the way a subsequent court interprets Section 37 and its scope. This is especially important because, let me see. Okay, no, I'm getting to the payoff later. So this is my first suggestion, that Section 37 really should be read as solely substantive. And if I may just go back for a bit, this does make sense if you look at the header of this section. I know there's some controversy over how much headers should influence interpretation, but I think in Singapore it's well established that it can at least help guide it. And the section itself purports to set out the standard of care for medical advice and not evidential heuristics with regard to it. So I think it would be perfectly consistent to say, well, it does what it says on the tin. This is talking about substantive requirements. It's not talking about evidence or cutting into anything that he provided in that respect. I think consistently with that, the illustration should really be interpreted as guiding the court and not suggesting any sort of hands-offness in the court's review of expert determinations, or expert opinion rather, as to whether non-disclosure under the therapeutic exception or otherwise was permissible. And finally, I would suggest that the court should make more robust use, in appropriate cases at least, of the evidential tools identified in He. So just ordinary things like, well, are there reasons in an expert's testimony, given other opinions and other evidence of opinion, to doubt whether what they've said properly reflects the opinion that is out there, because it's the opinion that's out there really that is exculpatory and not the things said by a specific witness. So if we do all these three things, or rather if courts do all these three things, I think there are a few practical payoffs, and I realize my time is running short. I'm going to finish real soon. The first is doctrinal clarity, and there's an obvious aspect to it that I won't elaborate on. there's a less obvious aspect of it, which is that, well, if we don't have this doctrinal clarity, I think there are going to be some problems with the interactions with the new rules of court promulgated last year. Specifically, there's this provision, Order 12, Rule 3 of this piece of subsidiary legislation that requires parties to agree on one common expert if they can, preventing parties from relying on evidence from more than one expert, except with the court's approval, and allowing the court to appoint an additional expert. So all this would fit very uneasily with a reading of Section 37 that treats the opinion as being the things that the witnesses actually say. And this goes back to the previous presentation's question on, well, how many experts do you need to say something before that constitutes opinion, right? And that's a question that you won't end up asking if it's if one is clear about the fact that the opinion is something out there and it's just evidenced by whatever one witness or two witnesses or however many witnesses says in court. And finally, I think there's also an important element here of providing jurisprudential clarity to the whole question. I don't want to treat this in detail, but basically I think it's unfortunate that often when we talk about judicial humility or deference to professional opinion, we are discussing it mainly in terms of difficulties in assessing evidence. I think that's not actually at the heart of the existence of special rules for standard of care. And this is something that, again, the court and he observed. Even if you were, and this is my very last point, even if we could confidently say that, well, we've got the right view of the evidence, this camp is correct, the other camp is wrong, it would be inconsistent for the court to just say, well, if you are wrong, you're negligent. Because the whole point is that if there was uncertainty at the time, then you can't say, if a person acted reasonably otherwise, that they're liable just for having the wrong view. And in my view, substantively, that's the real reason for this kind of deference, the recognition that there can be more than one reasonable thing to do, not the doubt as to whether the court is getting the facts right. So with that, I've come to the end of my presentation. I'm happy to take any further questions by email if there's no time during the Q&A. Thank you very much for your attention. It's been a pleasure.
Thank you, Nicholas. Thanks for that deep dive into the new Singapore law, which dovetails nicely with what Gary has already done. It makes you almost think that statute law can do more harm than good sometimes. And I think that's also the topic of our next presentation by Dr. Silke Harder, who is a reader at the University of Sussex and a former colleague and friend of mine, still a friend, but a former colleague of mine. And his research interests are not only in the law of obligations, but also in private international law. And he's the author of a number of very, very regarded textbooks on torts law and the law of remedies in Australia. Okay, Silke, so you're going to talk about the Golem principle again, but this time in the context of an Australian statute that tried to codify that principle.
Yes, yeah, thanks, Norman, and thanks for inviting me to speak here. So I will also share my slides. Hang on. Okay. Whoop. Does it work?
It does.
Yeah. Okay. Yes. So actually, Dr. Liu made some of the points just now that I intend to make, but as Norman said at the beginning, sometimes you don't find presentations that tail with each other, and sometimes you do. So yeah, and again, I will refer to the Golem principle, but also or the trigger of the presentation is Section 5.0 of the Civil Liability Act 2002 in New South Wales in Australia. The background is that about 20 years ago, all the Australian states, not the territories, but all the states enacted statutory provisions on the standard of care of professionals. They were not all the same, some only for health professionals, some for all professionals. This goes back to a report which is called the Ip report, because the chairman was Justice David Ip. And This is now the provision in New South Wales, Section 50 of the Civil Liability Act, which says a professional does not incur liability in negligence arising from the provision of a professional service if it is established that the professional acted in a manner that, at the time the service was provided, was widely accepted in Australia by peer professional opinion as competent professional practice. And then secondly, however, peer professional opinion cannot be relied on for the purposes of the section if the court considers that the opinion is irrational. Strikes me, having listened to Professor Chan and Dr. Liu, that actually this is similar to the Singaporean statute that they were discussing. Now there's a controversy now in the interpretation of Section 50. And the question is, does this section require an actual practice at the time of the defendant's conduct? Or is it sufficient that you have expert witnesses in the courtroom who say that they would have done, or they think that it is appropriate what the defendant has done? So coming back to this distinction between substance and procedure that Dr. Liu already mentioned. And there are different decisions by the New South Wales Court of Appeal, which was noted in the case mentioned on this slide. Now, my point is not really to resolve this controversy, but to show the background. And that is that there is a confusion, I would say, in English law, in English common law, or conflation of two different principles. One comes from the Golem case, and the other one comes from the Maynard case in 1984. And they established two different principles. And just for the record, but it has already been mentioned, I think, by all of my preceding speakers, that neither of the two principles, Golem or Maynard, applies to the duty to warn of risks as clarified in Montgomery. So let's go to Golem. I think it's important just to look at exactly what was laid down in the cases. And it has been mentioned already, but let's look again. So Justice McNair said that a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular art. Putting it the other way around, a man is not negligent if he's acting in accordance with such practice merely because there is a body of opinion who would take a contrary view. Now it says practice accepted as proper. Now there's an ambiguity because you might wonder, does it have to be accepted at the time of the defendant's conduct? Or is it sufficient that it is accepted in the courtroom by expert witnesses? But it seemed quite clear from a speech Justice McNair gave just a few weeks before he gave this jury instructions that he meant that the practice must have been accepted at the time of the defendant's conduct. And in fact, his statement was interpreted in that way by Lord Scarman in Sidaway, who said the Golem principle may be formulated as a rule that a doctor is not negligent if he acts in accordance with the practice accepted at the time as proper by a responsible body of medical opinion, even though other doctors adopt a different practice. So the principle laid down in Golem requires something in the real world. It requires a practice at the time of the defendant's conduct, and the practice was accepted, widely accepted at the time of the defendant's conduct. There might be questions about what does practice mean, what does accepted mean, but my point simply is it requires something in the real world outside the courtroom. And I think it's also important to note that the Golem principle has an exception. I would say always had an exception, namely that if the whole practice is unsound, then of course it doesn't help the defendant. And that was clarified first by the Privy Council Edward Wong, Hong Kong case actually, but also then by the Court of Appeal in Hux and Cole and Patel and Daybells. Then we come to Maynard, now the other case, 1984, where Lord Scarman, so again Lord Scarman, said this: it is not enough to show that there is a body of competent professional opinion which considers that the defense was a wrong decision, if there also exists a body of professional opinion equally competent which supports the decision as reasonable in the circumstances. It is not enough to show that subsequent events show that the operation need never have been performed if at the time the decision to operate was taken, it was reasonable in the sense that a responsible body of medical opinion would have accepted it as proper. That's interesting. First of all, there's no reference to practice in this passage or elsewhere in the judgment. And also look at the end of the passage. Medical opinion would have accepted it, not did accept it at the time, but would have accepted it if they had been asked at the time. So Maynard basically says, if there are reputable expert witnesses in the courtroom who testify that they think that what the defendant did was proper, then the defendant cannot be found negligent. So Maynard is basically a rule of procedure in a loose sense, not in the private international law sense, loose sense, rule of procedure, what is going on in the courtroom. So the Maynard principle does not only cover a defendant who complied with an established practice, like Golem, it also covers a defendant who deviated from established practice. Yeah, if there are expert witnesses in the courtroom who said, oh yeah, that was good, that was okay. The Maynard principle also covers a defendant who faced a novel scenario for which no practice had been established. So the Maynard principle is much, much wider than the Golem principle. The Maynard principle has an exception, Bulito, a logical opinion. I don't need to say more about that because you are aware of that. Now, and maybe I should make the point here, Bulito is an exception to the Maynard principle. It is not an exception to the Golem principle. The Golem principle didn't need an exception. It always had one. Yeah, Edward Wong, Huxham Cole, and so on. Now, what one might expect now to have happened is that because the Maynard principle is much wider than, oh, I should also say, sorry, that if I go back to this, Lord Scarman in Maynard, he cited only one case in support of this proposition, a Scottish case. He did not cite Golem. He cited Golem only once in his judgment at the very beginning, just for the very general proposition that a professional is judged by the standard of a professional and not by the standard of the ordinary person on the Clapham omnibus. Yeah. So one might not now have expected that after Maynard, basically the courts just refer to the Maynard principle and Golem basically becomes forgotten. But the opposite has happened. Maynard is hardly mentioned, but the Maynard principle is now labeled the Golem principle. And I don't know whether it was the starting point, but it might have been one of the triggers of it. And that's the statement by Lord Brown Wilkinson in Bolito, who said, the locus classicus of the test for the standard of care required of a doctor or any other person professing some skill or competence is the direction to the jury given by Justice McNair in Golem. It was this test which Lord Scarman was repeating in different words in Maynard's case. Now that is wrong. That is simply wrong. Sorry, but Lord Brown Wilkinson was wrong. Lord Scarman in Maynard did not restate the Golem test. He did not even purport to restate the Golem test. He laid down a different test. Now you could say the Golem principle and the Maynard principle have the same general purpose, they have the same justification maybe, but my point is simply they are two different tests. Golem is concerned with something in the real world, outside the courtroom. Maynard is just about the courtroom, the procedure, a rule of evidence. But this conflation or confusion, conflation I should say, has also been adopted in the literature. And I could give many examples, I just give one. Jonathan Herring's textbook, where it is said, the effect of the Golem decision is that it's difficult to show a doctor breached the duty of care. All that the defendant need to do to win the case would be to find an acknowledged expert to agree that the way in which the defendant dealt with the patient was within the range of acceptable practice. Now, what Jonathan Herring now states in the second sentence, that was laid down in Maynard. It was not laid down in Golem. Yeah, so again, you see the confusion here. And now coming back, doing the circle to Australia, all of that has now influenced the statutory reform in Australia. Now, at common law, the Australian courts did not adopt either the Golem principle or the Maynard principle. But then the IP panel, which I mentioned before, recommended an introduction of the Golem rule, as they put it, by statute. The problem is that the IP report was unclear as to whether they were actually referring to the Golem principle or the Maynard principle, yeah, following the conflation of the two principles in the literature. So the IP report said at some point, a medical practitioner is not negligent if the treatment provided was in accordance with an opinion widely held by a significant number of respected practitioners in the field, unless the court considers that the opinion was irrational. But does the opinion have to be present already at the time of the defendant's conduct or just in the courtroom? Also says, because there may be more than one opinion that meets the description in the recommended rule, it protects the practitioner who is at the cutting edge of medical practice, provided that the procedure followed was in accordance with an opinion that meets that description. So if it was at the cutting edge, that implies it was a novel procedure. Yeah, so not something that followed established practice. So that would mean Maynard principle, but not Golem principle. But it's not clear. I come to my conclusion. I don't know whether I'm still within the time or not.
Yes,
what I wanted to show is, that Section 5.0 is ambiguous, which is due to an ambiguity in the IP report, which in turn is due to an conflation of quite different principles in English common law. And so the lesson, because the title of the conference is, tort law reform, before you reform the common law, you must clearly understand what the common law actually says. Okay, thank you very much.
Thank you. So good. I think this.
How do I stop share? Stop share. Okay.
Yeah, I think this presentation really dovetailed again very nicely with the preceding ones. I think that the first question that flows from it, is is it very hard to reform the common law? And so basically, I think you both, Nicholas and Zirko, and to some extent Gary as well, were quite critical of the reform efforts. Do you think they've misfired in a way? First question to Gary and Nicholas first.
Okay, maybe I can go first, and then Nicholas can chip in later. Yes, I do think this Section 37, the new statutory framework in Singapore, does give rise to a real challenge. And it does show that it's hard to reform common law to some extent because of the way common law develops, right? It's over several cases over a longer period. And then for statute, you've got to condense it in a very specific way and it's as clear as possible. So as Nicholas has pointed out, it can give rise to issues relating to substantive law, as well as issues as to whether actually it relates to evidence. Maybe I'd like to point one issue that's not been dealt with by Section 37, which was not addressed in the presentation earlier. Because normally for Bola and Bolito, there is a, shall I say, a precondition before you apply Bola and Bolito, and that is that there must be some genuine difference in the opinions between two camps, difference in medical opinion. And this was actually mentioned in some of the common law cases. In fact, after E.G. Koch, there was another case in Singapore that talks about this. So where there's no genuine difference in the opinions between two camps, Bola and Bolito should not be applied. But in Section 37, it seems to be pretty automatic that they will apply Bola and Bolito as a standard of care. And then they talk about reliance on the professional opinion. without considering whether, even though it's a standard of care issue, whether there was actually a genuine difference in opinion. So this is another issue I think that's not really been, shall we say, considered in the statutory reform. Yeah. Thank you.
So if I could just add on to what Professor Chan has said, my answer as well is also yes. It can be difficult, and I would just want to add on an additional way in which the difficulty arises. I think it's very natural in legislative interventions to focus narrowly on the specific problem that has arisen and that is exercising the public or the profession. In this case, it was the tweak to the test, well, not tweak, the revolution of Montgomery and the modified Montgomery test with regard to medical advice. So the legislature reacted by changing just that, trying to change only the standard for medical advice. The problem is that when you do it that way, there are further confusions that can arise that I didn't even talk about in my presentation. With regard to the interaction between the stuff that wasn't changed to begin with and the stuff that was changed and then changed back. So when we look at Section 37 and what it has done with the Golem test, how it has codified the Golem test and then tweaked it a bit with regard to medical advice, how does that sit with the stuff that isn't covered by Section 37 at all? Medical diagnosis and treatment. How should a court react to that? Do you read Section 37 consistently as far as you can with the earlier case law on the Golem test generally? Do you take it that Parliament has some implied intention to have the common law conform in some broad way to the statutory intervention into one specific part of it? To me, it's really unclear, and that is just another example of the kind of uncertainty that can arise. And another reason, and the reason why I think that where possible, it would sometimes be better for Parliament not to try to be minimalist in its interventions. If you're going to codify Golem for medical advice, maybe you should just codify it for medical negligence generally, or just professional negligence generally, because that way then you at least have consistency across the domains and issues.
Sirkut, do you want to add to that?
Not really. There may be other questions. So yeah, I agree with my previous speakers.
Okay, so I guess statute law can of course sometimes be the expression of a preference in a particular jurisdiction. So one question that I got from an audience member was, do you think the changes that you considered, in Singapore and in Australia, were they actually, did they come out of a particular preference in the jurisdiction in question? What prompted the change in Singapore? Or maybe start with you, Sirkut, about the Australian changes.
Yes, the Australian changes. I mean, that was the introduction of the Golem rule by statute was part of a wider reform, and the main aim of the reform was basically to cut down successful negligence claims, to put it very bluntly, because there was an insurance crisis, or a perceived insurance crisis in Australia. So one insurance company got bust because just of the volume of claims, in particular in personal injury cases. And so the task for the IP panel was basically to suggest statutory reforms to make it harder for claimants to be successful in a negligence claim, to put it very bluntly. And the introduction of the Golem test was one of them. Also, they cut down on the amount of damages you can get, and so on. But that was the background. Very controversial up to today, whether that was ever necessary, but I don't think I think it will stay. Don't think it will be changed back to the common law.
Okay, and the position in Singapore, like, what was the prompt for the statutory reforms?
Maybe I can take first crack at this, but of course I'll defer to Professor Chan's views, if any. I think actually the reform in Singapore was prompted by some things that had very little to do really with medical negligence as a civil claim. The judgment in He, although it did unsettle the medical community somewhat, I think only had such a big impact because it happened to come out at a time when there were a bunch of disciplinary tribunal decisions coming out as well that the medical community felt were unreasonable. There were doctors who had been held, who had been disciplined and suspended for and fined for basically what most doctors viewed as just an error in judgment that anyone could make, that they weren't necessarily negligent. And ironically, these were determinations made by medical tribunals, not by the courts. So it's the doctors, senior doctors, who are perhaps a bit out of touch, holding more junior doctors liable. But all this got rolled together into a perception that the law is becoming increasingly inhospitable for doctors. And the perception, and all this is just my own view. I mean, it's to some extent speculative. The perception then became that there were all these rules being layered on top of doctors that made them take all kinds of precautions that they wouldn't previously have taken and that were impractical. And so when the civil law amendment bill came out, it was actually accompanied by amendments to I can't remember the exact name, sorry, but the act on medical professional obligations as well, and so it was seen as a two-part response to this perception that things were getting too tough for doctors. But I would actually speculate that if we hadn't seen those medical tribunal decisions, there wouldn't have been such an outcry with regard to Hitchcock and Montgomery.
Yeah, very interesting. So I've got a few questions from the audience, specifically on basically mental capacity. But perhaps before we go there, one more question for Chaitra. Because when you talked about the law in India and the influence of other jurisdictions and the case law from other jurisdictions on Indian law, do you think it makes it harder for countries that rely perhaps solely or predominantly on the common law to pick up on what happens in other jurisdictions, if there's statutory law that interferes and somehow disturbs the fabric of the common law?
Yeah, I mean, as India is concerned, we have tort law is not codified, and we have been relying upon the English courts. So also, as I clearly mentioned, it has been decided by the larger bench that Golem is the standard as far as determining medical negligence is concerned. Lot of cases have been, in lot of cases, the judges, courts have made an observation that it's time to shift away from the Golem test. But the fact of the matter here is, whenever there is a question of shifting away from the Golem test, the question arises whether the judge could intervene and decide on medical negligence cases, because most of the times it is felt that the doctor feels that it's only matter of medical judgment. So there is little hesitance seen to shift away from the Golem test. That's something that has been called, as far as India is concerned, to move away from the Golem test, because totally relying upon the courts to scrutinize the medical opinion has been difficult. That's why I was looking into if we could rely upon medical literature as US does and stresses more upon the scientific validity of the expert testimony to be one of them.
Okay, thank you very much. I've got another question that fits in here from Professor Jing Chung Yan, our colleague at City University. She asked, do you think the outcome of Montgomery would be different if Section 37 had been applied to the case? And if yes, how different would the outcome have been? She says it's a question for Gary and Nicholas.
Thanks for the question. I think that's a very good question. How would Montgomery be different if it's applied, if Section 37 applies to it? Okay, the thing about 37 is that after this so-called statutory reform, right, it depends on how the lawyers will respond to this particular reform and how they will craft the peer professional opinion in order to comply with Section 37. Right. So for Montgomery, I think this question is quite hypothetical in the sense that they did have to respond to that. Right. So the question is, if based on the facts, which is really about the risk of, I think, the spinal injury to that particular patient in Montgomery, whether the peer professional opinion would actually, how would they assess what sort of information that the reasonable patient would require, or what that particular patient would require. It's really, I think, a question mark in that sense, right? But if I were to make a guess, I think the particular patient concerns would be quite important in that particular case. I think she was quite an educated person with a science degree, if I'm not mistaken, in Montgomery. And she could ask pretty good questions. So if Section 37 would be applied there, then those specific concerns would actually have to be incorporated as part of the analysis in the peer professional opinion. So these are some of the changes I think that could arise if it would be applied under the Singapore's new statutory reform.
If I could just add on very briefly, I agree with that, and I think that the overlap between the substantive concerns in the Montgomery test and the mandatory considerations under Section 37, to me suggests that the likelihood of a different outcome would be actually quite slight, because things that we see in the Montgomery judgment regarding what the patient in that case was actually concerned about and had expressed, and things like objectively the degree of risk that the complications posed, all that would still feed into the mandatory requirements. And I think it would be unusual if the very strong conclusions that the court expressed in Montgomery would have changed just because they were being fed through a different kind of procedural lens.
Okay, thank you. I've got another question for Gary here from Joe Slavotsky, and he asks, well, he first thanks you for your wonderful presentation and then asks, what about informed consent and the allegedly incapacitated? How do courts ensure that a patient or his legal representative is adequately informed, or is there excessive discretion vested with medical professionals? So you're on mute now.
Thanks a lot for the question. I think it's a very interesting question. So this is a case where we assume that the person itself is mentally incapable. So if that's the case, if the doctor assesses him to be mentally incapable, then the question is whether he has appointed, say, a donee, a lasting power of attorney, or if there's actually a court deputy that is responsible for deciding on behalf of the mentally incapacitated person concerning his health matters. All right. Under the MCA, apparently there's a provision that says that for health-related matters, right, that power to decide has to be specifically mentioned in the lasting power of attorney. Okay. Let's assume it's in the lasting power of attorney. If so, then I think the doctor has to review all the relevant and material information, including the risks concerning a patient, to the legal proxy in order to fulfill the duty under Section 37. That would be my analysis.
Okay.
I hope that addresses. Yeah, thank you.
Yeah, thank you. I've got another question to you, Gary. So I think your topic created a lot of interest from an audience member, Shmuel Yerushalmi. And his question is, goes a bit somewhat wider than the previous one. you know. So do you see opportunities that are created or could be created for positive changes and reform to mental health law and patient rights in this area?
Personally, I think for Singapore at least, right, when we enacted the Mental Capacity Act, that really was, to me, a significant reform in itself, because I think on the whole it's quite protective of patients, for example, or even individuals who have mental capacity challenges. So under this reform, basically, there's a presumption of mental capacity. So the person, for example, in this case, doctor, wants to assert that the patient is actually not capable of deciding for his health matters. He has to show, right, based on the clinical test and functional test, that this is really so. Second, even though, right, there is good evidence that the person is not mentally capable, but it could be that patient's capacity is fluctuating in that sense. Apparently, doctors or persons involved in making these decisions, right, have to ascertain that at the point where he makes the decision, that actually he really doesn't retain any autonomy to decide, even though he may have that condition. So I think on the whole, it's pretty protective. I think it's protective of the patient's rights and not just purely autonomous decision making.
Okay, thank you.
Thank you.
I don't have any more questions from the audience, but I could imagine that you might have questions for one another, given that your topics were so closely related. So we've got just a few more minutes left, you know. So if you have anything that you want to ask of one another, or that you want to comment on, you know, colleagues' papers, you know, please go ahead. Well, that doesn't seem to be the case. So, you know, in that case, I think I'll, you know, close the session. It gives us a few more minutes break. Thank you to all our speakers, you know, for you know, basically sharing with us the insights from your respective jurisdictions, you know, from also showing, you know, the connections that we've been able to draw in the discussion later on. It's been a wonderful session. I've learned a lot, and I'm sure, you know, the other conference attendees did as well. So many thanks to you all again.